Let's discuss bylaws. Bylaws are covered by sections 45 to 47 of the Revised Corporation Code. And how do we define bylaws? The case of Loyola Grand Villas Homeowners Association versus the Court of Appeals defines bylaws as rules of action adopted by a corporation for its internal government and for the government of its stockholders or members, and those having direction, management, and control of its affairs in relation to the corporation and among themselves. The key phrases in the definition are internal government. So, at the onset, we should realize that with this definition, that bylaws only, as a rule, apply to the components of a corporation, meaning the stockholders and members and the officers of a corporation. The second key phrase is, it is for the government of its stockholders or members and its officers who have direction and management and control of the corporation. And finally, it is also for the purpose of governing the relationship between the components of a corporation and the entity, and that is the corporation. It has also been said that the power to have bylaws is inherent in every corporation. Section 45 deals with the adoption process. The adoption process referring to how the bylaws come into being and how they are going to be accepted as governing the internal goings-on or relationships within a corporation. So it says there that they are to be adopted by the affirmative vote of the stockholders or the members of the corporation, and this affirmative vote must be by a majority of the outstanding capital stock or of the members of the corporation. Take note that Section 45 does not make mention of any approval that comes from the board prior to adoption. It simply makes mention of an adoption by affirmative vote of the stockholders or the members, and the affirmative vote must be by a majority. The reason for this is when you speak of stockholders or members, they are already inclusive of your directors or trustees. Subsequently thereafter, this adopted bylaws is to be signed by the stockholders and members and kept in the principal office subject to inspection. And a duly certified copy by a majority of the directors or trustees, countersigned by the secretary or corporate secretary, is filed with the SEC and attached to the articles. There is also the possibility that the bylaws will be adopted and filed prior to incorporation. If it is adopted and filed prior to incorporation, there is a requirement that it is signed by all the incorporators of the corporation, and it is to be submitted simultaneously with the articles. So these bylaws, regardless of the form of adoption, will only become valid when the SEC issues a certification that it is not inconsistent with the Revised Corporation Code. And furthermore, the SEC shall not accept for filing or any amendment of a bank, banking institution, building and loan association, trust company, insurance company, public utility, educational institution, or any other special corporation that is governed by a special law until and unless it is accompanied by a certificate of the appropriate regulating agency that the bylaws as adopted or the bylaws as amended are in accordance with law. We now come to a question where no bylaws are adopted. In the discussion outline, I cited the case of Gokong Wei Jr. versus SEC 89 SCRA, page 364, where it was held that the non-adoption of bylaws would not result in the dissolution or demise of the corporation. And the reasoning advanced by the Supreme Court in that case is that this can be implied from the given power to a corporation to adopt bylaws and the absence of any provision that makes it a matter of necessity for the corporation to adopt bylaws, for it to have corporate existence, or for corporate acts to be validated. So from that point of view, it would seem that even without bylaws, a corporation may continue to exist and may also transact business. However, there is also the alternative view that the adoption of bylaws is a mandatory requirement. And the basis of that would be now a provision in the Corporation Code that if there are no bylaws, it would constitute a ground for a suspension or a revocation of the franchise because it may be a violation of the law. My advice is for you to keep these two schools of thought in mind if ever a question comes up as to the non-adoption of bylaws. Moving on to the elements of bylaws. In the discussion outline, you will see 6 elements of bylaws, and they are: they must not be contrary to the Corporation Code, they must not be contrary to morals or public policy. Third, they must not impair obligations of contract as a general rule. Number 4, they must be general and uniform in application. Number 5, they must be consistent with the articles. And number 6, they must be reasonable, meaning they must be capable of compliance. I also outlined and included in the discussion 3 cases where the validity of bylaws bylaw provisions have been decided and ruled upon by the Supreme Court. In the case of Peña versus the Court of Appeals, you have a situation where a provision in the bylaws states that the attendance of 4 members of a 5-member board for a meeting to void a resolution is allowable. Now, this stipulation is contrary to the code because, as we have discussed previously, when we speak of a quorum, we are talking of 1/2 plus 1. So when, in this particular case, the 3 members of a 5-member board had already decided upon the subject action, the provision in the bylaws where 4 out of the 5 can void the resolution was considered to be contrary to the code. In the second case that was cited, Grace Christian High School versus the Court of Appeals, we had here a situation where Grace Christian High School was made a permanent member of the board of the homeowners association of the place where Grace Christian High School was located or where it was situated. So in that particular case, Grace Christian High School or its designated representative was considered as a permanent member of the board. That was also considered and held by the Supreme Court to be contrary to law because membership in the board is pursuant to election. And the last case that was cited was Salafranca versus Film Life Village Homeowners Association. Here, the object, or rather the subject, would be impairment of an obligation because it had something to do with an amendment to the bylaws that abolished a particular position being occupied by a person. So in this particular case, the Supreme Court struck down the amendment because it would undermine the right to security of tenure of a regular employee, and that the corporation, simply by amending the bylaws and abolishing the position, could not deprive an employee of his right to security of tenure, thereby impairing an obligation. We now move on to the binding effect of bylaws on third persons. If you remember the statement, when we defined bylaws, we said it is for internal government. Since it is for internal government, the general rule should be it only binds stockholders or members, officers, and the members of the board, and of course the corporation itself. So since the general rule is that it is only binding upon them, insofar as a third person, it is not binding upon that third person. I made mention of two cases that would illustrate this principle. In the case of PMI Colleges versus NLRC, it was clearly stated that bylaws cannot affect third persons that deal with the corporation unless they have knowledge of the provision that affects them. Absent any knowledge or any indication that they were notified of a bylaw provision that would be material to their dealings with or transactions with the corporation, then any provision in the bylaws would not affect them. I also call attention to the ruling in the case of China Banking Corporation, where bylaws were described as being self-imposed and they have no status as public law. That is why, since they have no status as public law, we cannot apply the general principle where the ignorance of the law excuses no one. Because here, it is really a statement as to the private character of bylaws. So again, this discussion would be relevant to a question involving a third person. So when you find that situation, or you find yourself addressing that situation, and you are now going to be asked whether a third person is bound by a provision in the bylaws, the way to address it first is to go with the general rule, and that is no, a third person is not bound. Then look at the exception being unless he has been specifically notified of the provision in the bylaws that would have a material effect on the transaction with the corporation. So you now move on to determining, has he been notified? Absent any indication of clear notification, then your conclusion would be the third person is not bound by that provision in the bylaws. Moving on to contents. I invite your attention to section 46 where there is an enumeration of the contents of bylaws. I'd like to call particular attention to only one item, and that is insofar as the qualifications of directors and trustees and the need for their duties and responsibilities to be stated in the bylaws, together with guidelines for setting compensation for directors or trustees or officers, and the maximum number of other board representations that an independent director or trustee may have, which shall in no case be more than the number prescribed by the SEC. Because if you do a comparison of the provision prior to the amendment, this is what has been added to the provision. And I also call attention to our discussion on the rules that cover independent directors, because that is where you will see the prescribed number. Furthermore, if you recall, the Articles of Incorporation may provide for an arbitration agreement. Section 46 also provides that an arbitration agreement can be included in bylaws. So this means now, if you have put your arbitration agreement in the bylaws, then that would likewise be okay. If you have put it in the articles already, then there is no necessity to put it in the bylaws. At any rate, if the issue that you will be faced with or the question asked of you would be contents, then you can just simply, and if you have forgotten what the law specifically provides, then what you have to enumerate are those rules that apply only within the corporation, because those are the things that are required to be stated in bylaws. So this concept will also help you if you are going to be asked regarding a particular situation, and that particular situation, the question related to that particular situation is, should it be in the bylaws or is it allowed to be in the bylaws? So you simply ask yourself, is it something that is applicable to those who are within or inside the corporation? If yes, then it should be in the bylaws. If otherwise, then it's not required to be in the bylaws. Moving on to section 47, insofar as amendments. Section 47 provides that the amendment, the repeal, and adoption of bylaws can be undertaken by a majority vote of the board and a majority vote of stockholders or members in a meeting duly called for that purpose, or by the vote of the board if the power to amend has been delegated by a 2/3 vote of the outstanding capital stock or of the members. I'd like to point out something or a discrepancy between Section 45 and Section 47. Because what Section 47 says is that amendments, repeal, and adoption of the bylaws can be undertaken by a majority vote of the board. It is my opinion that this statement really should be reconciled with Section 45 and may have been missed out when the law was being deliberated upon prior to its approval. So that's the first way, or there are now two ways to amend it. So you have majority vote of the board and a majority vote of the stockholders or the members. And the other way is by a majority vote of the board only, provided the power to amend has been delegated by a 2/3 vote of the outstanding capital stock or of the members. If the power has been delegated, there is the matter of a revocation. The power of delegation, the power to amend as delegated can be revoked by a majority vote of the outstanding capital stock or of the members. Take note also that the provision, while it says by a majority vote of the stockholders or members at a regular or special meeting, there is the omission of the phrase at a meeting duly called for that purpose. In other words, the revocation can happen in any meeting. There is no necessity for a meeting to be called specifically for purposes of a revocation. Subsequently thereafter, once the amendment has been completed, the amendment now is to be submitted to the Securities and Exchange Commission attached to the original bylaws, and it becomes effective upon issuance by the SEC of a certification that it is in accordance with the code and other relevant laws. Needless to say, if it is a corporation regulated by a specific government agency, then there should also be a favorable recommendation or a certification that the amendment is not contrary to law. Finally, we now distinguish your bylaws with the articles. How do we distinguish it from articles? So there are three ways by which it can be distinguished. First, the articles are the fundamental law of a corporation. The bylaws provide for rules and regulations. Second, the articles are executed prior to incorporation, while bylaws are usually executed after incorporation. But as we discussed earlier, they may likewise be executed and adopted simultaneously with the articles. Third, the filing of articles is a condition precedent to incorporation, while the filing of bylaws may be a condition subsequent. And the last item would be determining or resolving a conflict between articles and bylaws. This is an easy question to resolve because in case of a conflict, the articles will always prevail over the bylaws, because one of the essential requisites of bylaws for their validity or for its validity is that it should be consistent with the articles. I again cited the case of Loyola Grand Villa's homeowners because it also dealt with a situation where there was a conflict between the articles and the bylaws insofar as the number of directors. The Supreme Court in that particular case upheld the number as stated in the articles. So that is our discussion for bylaws. And for the next discussion, we will now do meetings.